and notwithstanding anything contrary contained in the code, where the corporate insolvency resolution process or the liquidation proceedings of the CD is pending before an NCLT, an application relating to the CIRP or liquidation or bankruptcy guarantors, as the case may be of such CD, shall be filed before such NCLT. So second jurisdiction comes from the place where there is already CIRP is initiated or process of liquidation is initiated against the CD and it is pending before some NCLT. Then application relating to that CIRP, that liquidation or the bankruptcy guarantor shall be filed before that NCLT. Thirdly, CIRP or liquidation or bankruptcy proceeding of the corporate guarantor or personal guarantor, as the case may be, of the CD is pending in any court or tribunal shall stand transferred to the adjudicating authority dealing with the CIRP or liquidation proceeding of the such corporate debtor. So where CIRP proceeding of the corporate guarantor or personal guarantor is filed and corporate CIRP is already pending before such NCLT, then the proceeding of the corporate guarantor or the personal guarantor shall be transferred to such NCLT, adjudicating authority means NCLT, dealing with the CIRP or liquidation proceeding. The NCLT shall be vested with all the powers of the DRT as contemplated in Part 3 of the Code for the purpose of this subsection 2. Where personal guarantor is taken, then all the powers of the DRT that is available, that shall also be presumed to be there with NCLT for dealing with such personal guarantors. Notwithstanding anything contrary contained in any other law for the time being in force. This becomes very important section, subsection 5. Section 60, subsection 5, where maximum proceeding these days are filed, is under this section. Because anything that is relating to the CIRP or relating to the liquidation process are covered in this particular section very widely. Any question of law or facts. So keep this section very clearly in mind. Notwithstanding anything contrary contained in any other law for the time being force, NCLT shall have jurisdiction to entertain or dispose of any application or proceeding by or against the corporate debtor or corporate person. Any claim made by or against the corporate debtor or corporate person, including the claims by or against any of its subsidiaries situated in India. So any claims relating to the corporate debtor or even to its subsidiaries are covered in this. Or any question of priorities or any question of law or of facts. Now this is very wide. If you see this subsection C, it says that any question of law or facts, I mean most of the things that we go for adjudication or go for the direction of the court is about the question of law or facts. So this language itself is very wide to cover probably everything which is otherwise not covered in the previous sections. So that therefore this section becomes very important, section 60 subsection 5, where you have very wide coverage that everything relating to CIRP or liquidation shall be filed before the NCLT. No other court will have jurisdiction. Any question of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceeding of any corporate debtor or corporate person under this code. I hope you know what is corporate debtor and corporate person. Corporate debtor is a section 7 and section 9 application come where the corporate debtor comes, whereas corporate person is a where the company itself go for the insolvency section 10 application or where it goes for the voluntary liquidation under 54A. So in that situation, corporate person is the name used because the company itself is going. They may not be debtor. They may or may not be. So that is how the corporate person is used. Section 63, civil court not to have jurisdiction. No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter on which the NCLT, NCLT has jurisdiction under this code. So when you read this section 60 or subsection and section 65, 63, it is very clear from the language of the sections that anything relating to CIRP or relating to the liquidation or relating to personal guarantor shall be filed before the NCLT and no other civil court shall have ever jurisdiction. Many times client comes to me, especially on the real estate side, that home buyer come to me saying that I want to file application before the RERA court or I want to go to consumer court or I have few security from the builder, so I want to security checks are available, so I will deposit that check and then get the check bounce and then go for 138 proceedings, etc. All these remedies they seek But at the same time, once the company is gone into insolvency, these proceedings, you must understand that thereafter for civil proceedings, not coming to the 138 proceeding or cheating case or those, but for civil proceedings, it is only the NCLT which will have jurisdiction. So all the proceedings relating to about that corporate debtor shall be filed before the NCLT only, and no other court shall have jurisdiction. So consumer court or RERA court shall not have jurisdiction to entertain the suit or proceedings that you file in those courts once the company has gone into CIRP or liquidation because of the moratorium that is levied under Section 40. So therefore, only NCLT will have jurisdiction for civil proceedings. However, the criminal proceedings are outside the purview of it. Criminal proceeding can be filed anytime. It is not covered within the moratorium. So therefore, you can file criminal proceeding. You'll say, sir, why criminal proceedings are outside the purview? For the very reason that criminal proceedings are not filed against the corporate debtor. All the proceedings against the corporate debtor are barred. That is where the moratorium applies. That is where the jurisdiction of NCLT comes into picture. So far as criminal proceedings, they are filed against the individual directors. So therefore, it has nothing to do with the moratorium imposed by the CIRP or liquidation proceedings. And therefore, criminal proceeding can anyway simultaneously continue in addition to the proceedings that are there in the CIRP or proceedings that come before the NCLT. But no other civil court will have jurisdiction to entertain any proceeding relating to the CIRP or liquidation or any proceeding against the corporate debtor who is under CIRP or liquidation. So let's try and understand what kind of drafting is needed when you draft, when you are talking of drafting and pleadings. What kind of applications you have to file for the CIRP? The application for the CIRP can be filed. Who can file first of all this application? By financial creditors, individually or jointly. You need to understand this section 7, which deals with the application to be filed by the financial creditor. It can be filed either individually by each financial creditor or it can be collectively jointly by the financial creditors. There is no bar on that. However, when the application can be also be filed by the operational creditors. So who are the operational creditor? Maybe an employee, maybe government for taxation purpose, maybe supplier of the goods or services. So they are all operational creditor. However, they can file application only individually. So therefore, the threshold also when it comes for the CIRP for 1 crore and above, the threshold also it's individually. Whereas for financial creditor, even the threshold comes with a joint application and joint. Third is corporate applicant, that is by the company or the corporate debtor itself. So that is under section 10 application. So section 7 application, section 9 application, section 10 application, which is filed by financial creditor or operational creditor or corporate applicant as the case. Now once this application is filed, how will NCLT determine that whether this application should be granted or it should be rejected? So NCLT, there are criteria to this. NCLT have to just satisfy itself with 4 to 5 basic criteria. Once they are satisfied that these things are there, NCLT is bound to pass the order for CIRP. They do not have choice here. So what are those criteria? I think there are recent judgment also on this that NCLT had denied application under section 10 saying that the application was not served on the bankers or financial creditors. And then in appeal, the court had very categorically said that you cannot deny the application on these grounds. There are specific ground on which the application has to be accepted. Once you are satisfied with this ground, you are bound to accept it. So, what are the criteria based on which the NCLT would admit the application that is given under section 4? It says that there should be a debt. It should be ascertained and undisputed debt. It is coming from the precedent of judgments. Secondly, there should be a default of an amount of rupees 1 crore or more. So default should be more than 1 crore. Thirdly, application should be complete in all respect. So the application which you filed is carrying all the requisite supporting documents and evidences that is required to be established along with the consent of the IRP in Form 2. Fourth, no disciplinary proceeding against the proposed IRP. So proposed IRP which you recommended in the application, there should not be any disciplinary proceeding going on against that IRP. And fifth, no fraudulent intention in making such application. So this especially comes under section 10 application, that this application is not filed mala filely with the intent to defraud the creditor or those kind of things when you file this application. Section 10 application is more about the fifth point, where no fraudulent intent for making the application. Otherwise, for rest of the applications, is only 1, 2, 3, 4. Four criteria has to be met. There should be debt, there should be default more than 1 crore, application should be complete in all respect, and no disciplinary proceeding against the IRP proposed. So these are the criteria based on which the NCLT has to determine the application and admit the application by passing the order of CIRP. उसमें सबसे important होता है कि establishment of the debt. There should be a debt of more than 1 crore or default of more than 1 crore. So debt be legitimate and undisputed one. If it is disputed, the court will have to adjudicate it, and whether it is more than 1 crore. That's it. They have to just establish the criteria that debt is more than 1 crore, irrespective of whatever dispute. For example, 60 crore ka claim and other party is claiming 60 crore, not 50 crore is there. Fair enough. 50 crore ka to is more than 1 crore. So then rest of the things will be determined by the IRP. But admitted debt should be more than a crore. So that is the criteria. Various other applications by the stakeholder or party agreed. So apart from these, Section 7 application, 9 application, or 10 application, there are various applications which are filed by various stakeholders for various purposes. You may find Section 19(2) application, Section 43 preferential payment application, fraudulent application, for fraudulent transactions, Section 66 application, 45, 49 application, various application for extension of time beyond 180 days, application for. So there are many applications which are filed by various stakeholders from time to time, including application for replacement of the IRP, replacement of the authorized representative for home buyers. Various applications are filed. So in NCLT, for one CIRP, you will find there are a plethora of applications which are filed in any CIRP. So that usually all those applications are covered. Maximum of these applications are covered under Section 60, Section 5. Apart from few applications which are going through the specific sections. The rest of the application go under Section 60, subsection 5. So that becomes very important. Thirdly, CIRP or liquidation bankruptcy proceeding of the corporate guarantor or the personal. Sorry, I have gone back. Financial creditor either by itself. Now we are going through Section 7. So what Section 7 says and what are the documents you have to attach when an application is filed for CIRP by the financial creditor under Section 7. So we'll go through that, how it is required to be filed. What are the annexes and exhibits you should attach in your pleadings. So when you are drafting it, so far as drafting it is very, very simple. You just have to fill up the form 1, especially when it comes to Section 7 application. So form 1, specific standard format, you don't have to apply too much of your mind. Standard things are there, you just have to apply that. And you have to fill up the form, and along with that, you have to annex these documents. The documents become very important evidences. So financial creditor either by itself or jointly with another financial creditors or any other person on behalf of the financial creditor as notified by the central government may file an application for initiating CIRP against the corporate debtor before NCLT when a default has occurred. So what is important here again is default. You know that default should be of more than 1 crore. A default includes a default in respect of the financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. The financial creditor shall make an application in Form 1 with fees of rupees 25,000 along with what other things they have to attach. One, you have to attach the record of default available with the IU information utility or such other record or evidences of default such as, so either you put up the simply record of default with the information utility, that's the best evidence, or in alternative, you can also put the other records or evidence of default. What are those records? The financial contract, that is your loan agreement, hypothecation, mortgage document, all these things. A record evidencing the amount committed by the financial creditor to the corporate debtor under the facility has been drawn by the corporate debtor. So the amount which is drawn by the corporate debtor, that is also required to be proved. I'm sure you know what the financial creditor is, right? Financial creditors are bankers, financial institution who is granted the loan. So document relating to those loan documentations, those evidences relating to how the amount is withdrawn, that is required to be established and proved. So those are the supporting documents required to be attached. So financial contract, that is loan documentations. Secondly, amount drawn by the corporate debtor, so record evidencing that, so bank statement and those kind of things. So whatever, sanction letter, so how that amount was withdrawn, all those information is required to be submitted. Third is financial statement showing the non-payment of debt. What is financial statement is nothing but the bank statement. That will show that there is a default. Every time the loan has been, the amount which was tried to recover was bounced. Fourth, the order of the court or tribunal, if any. So if you have procured any order from any other court, maybe from the DRT, from the, under the DRT law or under the SURFACE law, so those order, if you obtain from any other court, that is also can be a supporting document. And the last one is where the applicant is assigning or transferring of the financial contract, a copy of the assignment deed or other relevant documentation to show the assignment. So where the debt has been assigned, especially in the SURFACE and securitization mechanism. So if the debt has already been assigned pursuant to that, then those documentation, the assignment deed or other related documents are also required to be attached. So as a financial creditor, who can file the financial creditor? When you say, if you see the very language, it says that financial creditor by itself or jointly with other financial creditor or any other person. Now, who is that other person on behalf of the financial creditor? So, as per the notification of the central government on 27 to 2019, they are either the guardian or that is in case of minor, that is the guardian or an executor or administrator of the estate of the financial creditor or the trustee, including the debenture trustee and the person duly authorized by the board of directors of the company in case where the company is there. These are the person who are authorized to file the application on behalf of the corporate debtor. So next is rule 2A, that is coming from the rules and regulations, that is adjudicating authority rules. What it says, record or evidence of default by the financial creditor. These are also required to be attached. So first thing what you attach were these entire records which we saw coming from the Act itself, Section 7. Now coming through the rules. What rules provide? What other documents are required to be attached? For the purpose of Section 7(3)(a) of IBC, financial creditor may furnish the following record or evidences of default, namely the certified true copy of the entries in the relevant record of the Banker's Book Evidence Act, as defined under Section 2(3) of the Banker's Book Evidence Act 1891. So those entries or relevant account are required to be produced or attached. And of the court or tribunal that is adjudicated upon the non-payment of the debt where the period of appeal against such order has expired. So that particular court order, as I said, from DRT or SURFACE can be produced so far as the appeal is not filed or the period has not expired. So far as the appeal period has expired, sorry. So once the period is expired for appeal, you can always produce this as an evidence. The second thing or the second point which you need to annex to your application is consent of the proposed IRP in Form 2. Everywhere you will see this, that you need to recommend IRP or interim resolution professional in Form 2. Their consent is required to be obtained and attached to the application. In all the three applications, whether by financial creditor or by operational creditor or by corporate person itself, corporate applicant. So in all the three cases, you will find this standard that you need to obtain consent of the IRP to act as IRP in the matter. So you have to obtain consent from the insolvency professional who is ready to accept this assignment as a IRP and you have to annex this consent in Form 2. And thirdly, any other information specified by IBBI. So any other information specified by IBBI that is under Regulation 2A what we saw. That is IBBI's regulation. An applicant shall serve the copy of the application to the registered office of the corporate debtor and to the IBBI by RPAD or by speed post or by hand delivery or by electronic means. That is by email. Most of the time we now do is email. We simply email the proceedings to the corporate debtor as well as to IBBI before filing it to NCLT. Now IBBI has given the portal, so you just have to go and upload those things in the portal and the application can be filed. NCLT shall within 14 days from the receipt of the application ascertain the existence of the default from the records of IUs or on the basis of the evidences furnished by the financial creditor. However, if NCLT has not ascertained the existence of the default or passed an order as set out below, within such time, it shall record the reasons in writing. So within 14 days, they have to pass the order. Practically, it never happens. We all know that it takes time, but that is what NCLT provide, and NCLT envisage that this order should be passed within a period of 14 days, either to admit or to reject the application. Next is where the NCLT is satisfied that the default has occurred. What they have to satisfy themselves? The default has occurred, more than 1 crore, of course. The application is complete and there is no disciplinary proceeding pending against the proposed IRP. It may by order admit such application, or else NCLT may reject the application by giving 7 days notice to the applicant to rectify the defect in any application. So if there is any defect in your application, definitely NCLT come out with that defect and send you nowadays by email, because things are virtual. Again, I was disconnected.
Yes, sir. Yes, sir. But now you are audible.
Audible, right? My screen is visible.
Yes, sir. It is visible.
Great. So, provided that a financial creditor referred to in A and B of subsection 2 of the creditor, an application for initiating of the CIRP against the CD shall be filed jointly by not less than 100 of such creditors in same class, and not less than or not less than 10% of the total number of such creditor in the same class, whichever is less. Now, what is this? Who can file the application in that? There is something called class of creditors. So maybe a debenture holder, deposit holder, or say home buyers. They form a separate class. So when they form a separate class, just they don't have to fulfill just only one criteria, that there should be debt above 1 crore. They also have to ensure that, to avoid any misuse by misuse filing the proceeding, this kind of provision was brought. They have to jointly file this application by not less than 100 of such creditor, or not less than 10% of the total number of such creditor of the same class, whichever is less. So कम से कम 10% तो class of creditor चाहिए. एक creditor नहीं कर सकता. For example, I have purchased a flat from a builder in 1.5 or 2 crore rupees, and 2 crore have paid to the builder. Tomorrow builder is not giving me possession. I cannot simply drag him to the NCLT and say that I am not given the possession, or I have a debt which is of more than 2 crore rupees. Refund is available. I may obtain order from the RERA also, RERA court, that I am entitled for the refund along with the interest, which is having more than 2 crore worth. But I have to, in addition to that criteria of more than a crore, I also have to fulfill the criteria of having 100 creditors, hundreds of such, or at least 10% of the total number of the creditor, whichever is less. So any of these, whichever is less. Provided further that financial creditor who are LOT under the real estate project, that is home buyers, an application for initiating CIRP against the corporate debtor shall be filed jointly by not less than hundreds of such LOT under the same real estate project, or not less than 10% of the total number of LOT under the same real estate project, whichever is less. So when you are looking about real estate project, then you require the financial creditor to hold at least 100 of such LOTs, or 10% of the 10% threshold. Either of this, whichever is less, of course. So Either of these persons can file the application before the NCLT for initiating the CIRP. So that is all about the application that can be filed by the financial creditor. Next is application that can be filed by the operational creditors. In operational creditor, what is the structure? Here, you first have to give the notice to the operational creditor about recovering your dues. However, if that notice, demand notice is not honored into or ignored by the operational creditor, then you can file the application. And that 10 days timeline is there for operational creditor to either dispute your claim or to make the payment. So that is a basic criteria which was not there in financial creditor. Section 7 application, you don't have to give any notice to the corporate debtor. However, here you have to give notice to the debtor, 10 days notice. So let's see, that is section 8 and section 9. Section 8 deals with the notice. So notice by the operational creditor. On occurrence of the default, operational creditor shall deliver to the corporate debtor the following documents. What is required to be delivered? One is the demand notice in Form 3 or the copy of the invoice attached to the notice in Form 4 at the registered office or by hand delivery or by RPAD or by speed post with acknowledgement due or by email service to the whole-time director or designated partner or KM, if any, of the corporate debtor. Copy of the demand notice or invoice demanding the payment served by the operational creditor shall be filed with the information utility, if any. The corporate debtor shall, within 10 days of receipt of the demand notice or copy of invoice, bring to the notice of the operational creditor the existence of dispute, if any, or the record of pendency of suit or arbitration proceeding filed before the receipt of such notice or invoice in relation to such dispute. So either he raised the dispute by giving reply to the notice or raising dispute. That dispute should be legitimate dispute. Or is there any pendency of the suit or arbitration proceeding already pending before some court or arbitral tribunal? So if that situation is then, it is presumed that this is a dispute. That is the existence of dispute as defined under the Act itself. And secondly, the payment of unpaid operational debt by sending the attested copy of the record of electronic transfer of the unpaid amount from bank account of the corporate debtor or by sending attested copy of the record of the operational creditor as encashed a check issued by the corporate debtor. So what they have to do is within 10 days, either they have to raise the dispute by replying it, existence of the dispute they have to establish, or they have to make the payment. The corporate debtor has to either make the payment and then provide the proof of payment within 10 days, all these things. What happens if that 10 days it doesn't work? I mean, neither the payment is made nor the existence of dispute is established. Then, after expiry of 10 days, that is section 9 now, after expiry of 10 days from the date of delivery of the notice or invoice demanding the payment, if operational creditor does not receive payment from the corporate debtor or notice of dispute section 8(2), the operational creditor may file application before the NCLT for initiating CIRP in Form 5. Again, the form is very clearly given. You don't have to make your own separate pleading or proceedings. There is a form available. You just have to fill up the form. That's it. कोई ज्यादा complicated नहीं है ये. जैसे सेक्शन 7 एप्लीकेशन में फॉर्म 1 इज अवेलेबल, सेम वे फॉर्म 2 इज फॉर्म 5 इज अवेलेबल फॉर ऑपरेशनल क्रेडिटर. क्यों फॉर्म 5? Because form 2 is what is form 2? Consent of the IRP. Form 3, demand notice. We saw under section 8 now. 4, form 4 is invoice. Attachment of all the invoices. So ये सारे form वही है. और next is form 5. So form 5 comes again with the application to be filed by the operational creditor, along with the fees of rupees 2000. So वहां पे जबकि फीस 25,000 था, यहाँ पे उसका 110 थे almost. Accompanied by the following documents. What documents are required to be attached? These are the documents which are required to be attached to the application. This is very important. A copy of the invoice demanding the payment or demand notice delivered to the operational creditor to the corporate debtor. Delivered by the operational creditor to corporate debtor. Next is affidavit to the effect that there is no notice given by the corporate debtor relating to the dispute of the unpaid operational debt. A copy of the bank certificate confirming that there is no payment of any unpaid operational debt by the corporate debtor if available. So again here the word if available is added. Originally it was not there, which makes this provision very directory. कि बैंक सर्टिफिकेट पहले क्या होता था, लोग बैंक सर्टिफिकेट लेने जाए बैंक मैनेजर देता नहीं था, तो नहीं देता है, फिर टाइम पास होता था एंड दे कीप ऑन यूज्ड टू रिमाइंड द बैंकर्स टू प्रोवाइड द बैंक सर्टिफिकेट एंड बैंकर्स वर नॉट गिविंग. They had their own hesitations and apprehensions about giving certificate. तो उसके ऊपर important judgment भी pass होते, banker is supposed to give this certificate because they are supposed to follow the law of land, etc. But ultimately, what they made is they made this provision itself directly, so that bankers के ऊपर depend ना हो जाए तुम्हारा application. A copy of record with the information utility confirming that there is no payment of an unpaid operational debt by the corporate debtor if available. So if you file the record with a information utility, then copy of that is also required to be given. Any other proof confirming that there is no payment of unpaid operational debt by the operational creditor, or such other information such as the contract for supply of goods or services. यानी हो सकता है आपने परचेज ऑर्डर रेज किया हो या जो भी हो, कॉर्पोरेट डेटर के साथ जो भी आपके कॉन्ट्रैक्ट है वो सारे आपको देने हैं. Order for the court or tribunal that is adjudicated upon non-payment of the debt. So if you have tried any or made any efforts in any other court, for example, recovery suit is filed, summary suit is filed, where the court has adjudicated that this amount is due to you and payable to you, then that order of the court or tribunal is also required to be filed. And financial account means your ledger, your ledger or the book confirmation of accounts made by the operational corporate debtor. All those things are required to be attached. Apart from that, what is required to be attached? Form 2 of the proposed IRP, which you are aware. And what IBBI regulation says, in addition to what is given in the Act, there are certain things which are from the adjudicating authority rules and regulations framed by IBBI. So what are those regulations said? It says you also have to put up the record or evidence of the transaction or debt or default by the operational creditor. In Rule 2B, it says that the operational creditor shall, along with the application under Section 9, furnish the copy of the relevant extract of GSTR 1 and Form GSTR 3B, that is GST, proof of payment of GST. When you are raising the invoice for supply of goods or services, तो आपने उसके ऊपर GST तो भरा होगा, उसका भी proof आपको अटैच करना है. Is filed under GST law and the copy of e-way bill wherever applicable. So provided provisions of this regulation shall not apply to those operational creditor who do not require registration and those goods or services which are not covered under GST law. So it applies only to those goods or services where GST applies, or those products or regulation where GST applies or e-way bill applies. Say for example, it's a lawyer. If we are claiming the claim, we are not bound to pay GST. Sir, we are covered under the reverse mechanism. So हमें तो वो apply नहीं होता, तो हम GST का invoice कहाँ से लाएंगे? So in those situations, it is not required. It's that simple. In that case, we just have to establish that is more than a crore rupee. That's it. Applicant shall serve by RPAD or by speed post or by hand or by electronic means a copy of the application to the registered office of the CD and to the IBBI before it is filed with the NCLT. And ये सारा process same है, which is there also in the financial creditor we discussed. It's the same process. The NCLT shall within 14 days of the receipt of the application by order either admit the application and communicate such decision to the operational creditor and corporate debtor if any. And if the application is complete in all respect, if there is no payment of the unpaid operational debt, invoice of the demand notice to the corporate debtor has been delivered to the operational creditor and no notice of dispute has been received by the operational creditor, or there is record of the dispute in IO. So no dispute has been raised basically, and there is no disciplinary proceeding pending against the IRP. So this is what the NCLT will satisfy itself before passing the order. Or else the NCLT shall reject the application by giving 7 days notice to the applicant to rectify the defect in this application, and CIRP shall commence from the date of admission of the application. So within 14 days, of course, practically it never happens that within 14 days NCLT has passed any such order, but that is what is envisaged by the IBC regulation, IBC Act. Now, The next third application, section 10 application, where the corporate applicant has committed a default. A corporate applicant may file file with NCLT an application in Form 6. So this application, which is filed by the corporate applicant itself, not by the financial creditor, not by the operational creditor. It is filed by the corporate applicant itself for initiating CIRP. What is here to be noted is that there should be a default of more than a crore. हर जगह पे डिफॉल्ट तो है ही 1 करोड़ के ऊपर का. यहाँ पे कंपनी खुद फाइल कर रही है एप्लीकेशन. कॉर्पोरेट डेटर इटसेल्फ फाइल्स द एप्लीकेशन. कॉर्पोरेट एप्लीकेंट इटसेल्फ फाइल द एप्लीकेशन. But how it is different? आगे आओगे तो section 54A में the corporate person itself file the application. Then what is the difference between section 54A, that is voluntary liquidation application, and application under section 10? Here section 10 application is filed not for the purpose of liquidation, for the purpose of CIRP first. We try to revive the company, and secondly, here the main criteria is there should be a default, means company is insolvent. Company is not solvent here. There is a default. Whereas section 54 application आप देखोगे तो वहां पे company is solvent. The declaration of solvency is required. And there the question of CIRP doesn't affect. यहाँ पे resolution नहीं करना है वहां पे. वहां पे company will simply go into liquidation. The intent is to liquidate the company, not to resolve the company. It's a stable company. There is no liability, or the liability can be paid off by the existing company. So voluntary liquidation में वो criteria है. But when section 10 application comes, यहाँ पे default है. यहाँ पे insolvent company है. There is a probable NPA also. So section 10 application is very different from 54A, as I said. And what are the criteria? That here it is required to be filed in Form 6. Again, form is available. You just have to fill up the form for initiating the CIRP against the corporate debtor, along with the fees of rupees 25,000. Just like financial creditor, यहाँ पे भी पूरा 25,000 का fees है. And following documents shall be attached along with the application. So pleading के साथ आपको attachment क्या क्या करना है, क्या क्या exhibits में डालना है, that is very important. The information of its books of account and such other documents for as specified for the specified period, that is 3 years. Form 2 of the proposed IRP and the special resolution passed by the shareholder of the corporate debtor. तो यहाँ पे इसके अलावा क्या देना है? Form 2 is of the proposed IRP, that is consent of the IRP, and special resolution which is passed by the shareholders of the corporate debtor, or the resolution passed with at least 3/4 of the total number of partners of the corporate debtor. Partners yani it comes in case of LLP. Approving the filing of the application. The applicant shall serve the copy of the application to IBPI by RPAD or by speed post or by hand or by electronic means before its filing with NCLT. NCLT shall, within 14 days of the receipt of the application by order, either admit the application if it is complete and no disciplinary proceeding is pending against the proposed IRP, or else reject the application by giving 7 days notice to the applicant to rectify the defect of the application. The CIRP is to commence from the date of admission of the application, that is insolvency commencement date. तो ये पूरा वो तो सेम ही है in every, whether section 7, 9 or 10 application. What documents are required to be attached, that is very important, along with your pleadings. So whatever filings that you are doing, baki form is very simple. It is given to you. You just have to fill up the form, explain the transaction. That's it. But all these exhibits are to be properly annexed when you are explaining the entire transaction. You have to exhibit all these documents and you have to annex it to the petition that you are submitting. This entire checklist of such other document are provided in Form 6. If you see Form 6 last में नीचे में पूरा checklist दिया है, ये सारे documents आपने annex किए हैं कि नहीं किए हैं, along with Form 6. So these are the ways in which it is filed in the NCLT. Apart from this filing of application for initiating the CIRP, we also need to understand what are the practical aspects. ये तो हमने सीखा, ये जो बुक में दिया है या जो हमने आईबीसी एक्ट में या रेगुलेशन या रूल्स में दिया है, एनसीएलटी रूल्स है या एडजुडिकेटिंग अथॉरिटी रूल्स है, वहां से ये प्रोविजंस हमने देखे कि ऐसा ऐसा ऐसी चीजें जरूरी है, या ये सारे डॉक्यूमेंट्स आपको एग्जिबिट करना। नाउ कमिंग टू द प्रैक्टिकल एस्पेक्ट, कि एक एप्लीकेशन जो आप फाइल करते हो या ड्राफ्ट करते हो फॉर इनिशिएटिंग द CIRP, तो उसमें और क्या क्या डॉक्यूमेंट्स लगते हैं, ये सारे एप्लीकेशन में लगेंगे। प्रोसीजर जो है, these are all practical procedures which you will find in every application that you file before the NCLT. You will see this. What you have to draft along with, for first thing you have to draft the requisite application. तो हमने बताया in whatever forms which are available, along with all the exhibits that are available. So जो आपका फॉर्म है, फॉर्म 1 है या 5 है या 6 है, जो भी है, so वो फॉर्म के साथ उसके सारे एग्जिबिट्स क्या क्या लगाने हैं, डॉक्यूमेंट्स क्या क्या एनेक्स करने हैं, वो वी हैव डिस्कस। बट इन एडिशन टू दैट, when you file an application, you also have to prepare more documents. What are those? As per that is as per the NCLT rules and NCLT's requirement. कई बार internal procedures NCLT की होती है, which differ from NCLT to NCLT. But otherwise, what is given in the NCLT rule? So, drafting of requisite application, then you have to, and along with that, you have to give them synopsis, that is brief summary of your case, wakalatnama, dates and events, memorandum of address, short index, long index, affidavit in support. Application shall get affidavit in support notarized and stamped. So applicant has to also get the affidavit in support notarized and stamped as per the law of the state. यहाँ मुंबई में होगा तो 100 रुपए के स्टैम्प पेपर पे होता है। Carrying out necessary administration work such as numbering of the pages, whitening wherever required, translation, xeroxing, printing, scanning, ये सारा चीजें करना है आपको as a lawyer. You all are doing this already. If you are filing the application before NCLT, you know that any application that you are filing in any court, I think this is common thing, administrative work. We all are doing this. So जहाँ पे कोई और लैंग्वेज में इंग्लिश में नहीं है, तो you have to bring it in translation in English. Similarly, e-filing of the company petition or IA or IBC. So आपको पता है, now everything is virtually filed also. So e-filing of the company petition and providing requisite details of basic e-filings, details of the petitioner, details of the respondent. If you file this, you know that किसी ने अगर फाइल किया है वर्चुअल फाइलिंग, तो उसमें सारे अलग 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 इंफॉर्मेशन के स्लैब्स है, which you have to provide this information. So details of the respondent or corporate data, detail of the authorized representative, that is advocate, uploading the petition or IA, proof of services, etc. at NCLT portal. तो NCLT के पोर्टल में सारी चीजें आपको अपलोड करना है. Those who have done that, they all know कि फाइलिंग होता कैसे. So you have to fill up all this information and dealing with the security of the filing by NCLT and dealing with the administration department of NCLT to remove any objection if any. So objection कैसे रेज होते हैं, आज के दिन में सब कुछ ऑनलाइन है, तो ईमेल्स आते हैं, ईमेल पे हम रिप्लाई भी करते हैं, ऑब्जेक्शन रिमूव करते हैं, अपलोड करते हैं. So all these things we do this these days. Then getting the application filing and lodging number. उसके बाद आपका lodging number भी आपको मिल जाता है. Submitting 2 sets of application or petition to the NCLT and service of the physical copy of the application to the corporate debtor. Filing of the affidavit of service with the NCLT if required by the Honorable NCLT. Moving receipt precipi for bringing the matter on board. Appearing and getting the court notice issued to the corporate debtor if needed. Filing wakalatnama and reply of the corporate debtor by the corporate debtor's advocate. So now coming to the corporate debtor side. So हमने appearances किया, उसमें फर्स्ट में अपने को समझाना पड़ता है कोर्ट को कि मैटर क्या है. Then the other party will file, that is the corporate debtor will file the wakalatnama of its lawyer and reply of the lawyer. Then we have to file rejoinder if required. If required, we have to obtain nowadays court order even to file the rejoinder. It's not in the normal routine process that rejoinder is required to be filed. So if you want to file the rejoinder, if you feel that there is something significant coming in the reply which needs to be replied in the reply of the corporate debtor, then rejoinder is required to be filed, and you have to obtain order or direction from the NCLT allowing you to file the rejoinder. Appearing and arguing the matter by both parties in case there is a dispute, and filing the written argument if any, reserve the order by the NCLT and uploading the order passed by the NCLT. So this is the entire process, how the NCLT functions step by step. सो हर चीज मैंने यहाँ पे की कि कैसे एप्लीकेशन फाइल होता है, कैसे अपलोड होता है, मैटर बोर्ड पे आता है, उसके बाद सामने वाला रिप्लाई फाइल करता है, उसके बाद अपने को रिजॉइंडर फाइल करना है, और उसके बाद आर्ग्यूमेंट होगा। आर्ग्यूमेंट के बाद रिटर्न आर्ग्यूमेंट फाइल कर सकते हैं, एंड यू कैन पुट ultimately the matter will be resolved for order. So that is how the proceedings are made before the NCLT. Pleadings are filed, drafted, and filed before the Honorable NCLT. Now, if you want to appeal these provisions, then what will happen? Where will you go for appeal? You have to go to appeal if any order is passed by the NCLT, which is prejudicial to you, and you have to appeal to that, then you have to go to the NCLT. So not उसके related जो है section 61 and 62. Section 60 we have read already, and section 63 we have read. Now we will read section 61 and section 62, which goes for an appeal provision to NCLT and from NCLT to Supreme Court. तो ये last provision से notwithstanding anything contrary contained under this Companies Act 2013, any person aggrieved by the order of adjudicating authority under this part may prefer an appeal to NCLT, that is National Company Law Appellate Tribunal, within 30 days. Timeline is 30 days. Provided that NCLT may allow appeal to be filed after 30 days, if it is satisfied that there is sufficient cause for not filing the appeal. But such period shall not exceed 15 days. So again, further extended period is up to maximum 15 days, so total 45 days. 30 days plus 15 days on sufficient ground. 15 days से ज्यादा allowed नहीं है. नो कंडोनेशन ऑफ डिले, नो फर्दर कंडोनेशन ऑफ डिले. उसके ऊपर सुप्रीम कोर्ट के जजमेंट भी है दैट इवन हायर अथॉरिटीज एनसीएलटी और सुप्रीम कोर्ट डू नॉट हैव पावर टू कंडोन द डिले. क्यों नहीं है, ये कभी सोचना चाहिए सर, क्यों नहीं है ये. अगर 45 से 46 डे हो गया तो नहीं है कंडोनेशन. डू अंडरस्टैंड दैट देयर इज अ टाइमलाइन गिवन. Because what is the problem? If you allow condonation of delay, which is unlimited period, maybe after a year or 2 years, then what will happen? For example, resolution plan is passed, it is implemented also, and thereafter someone is going for appeal after 2 years. Then what will happen? So it cannot be permitted. Timelines are very specific, very clear. So coming to an end, an appeal against an order approving the resolution plan under section 31 may be filed on the following grounds, namely approved resolution plan is in contravention of the provision of law. There has been a material irregularity in exercise of power by RP in the CIRP. The debt owned by the operational creditor for operational creditor of the corporate debtor have not been provided for in the resolution plan in the manner specified by IBPI, and the CIRP costs have not been provided for the repayment in priority of all other debts. Our resolution plan does not comply with any of the criteria specified by IBBI. Only on these grounds, a resolution plan can be challenged as given under section 31 of the IPC. इसके अलावा resolution plan challenge नहीं हो सकता. Most of the resolution plan is getting challenged because of the violation or the due process is not followed. So irregularity in exercising the power by the RP और वो सब ground पे resolutions get challenged. An appeal against the liquidation order. Now coming to the liquidation order, as under section 33 or 54L, that is relating to prepacked insolvency, or 54 and 4, that is termination of the prepacked insolvency, may be filed on the ground of material irregularity or fraud committed in relation to the liquidation order. So very limited ground on which the liquidation order can be challenged. Next is appeal against the contravention from P-packed insolvency. I still have a view कि liquidation order में इतना कम ground नहीं हो सकता. There are many time grounds where we have to challenge the order for liquidation and we seek direction from the court to meet kind of justice. Many times what happens, third party assets are included in the assets of the corporate debtor. लिक्विडेटर किसी थर्ड पार्टी का एसेट डाल देता है, थर्ड पार्टी को पता भी नहीं है कि उसका एसेट लिक्विडेशन एसेट में डाल दिया है, और उसके बाद जब पता चलता है तो वो चैलेंज करता है. तो पता चलेगा उसके बाद ही चैलेंज करेगा ना. तो कैन वी से कि 30 डेज तो एक्सपायर हो गए, उसको तो पता भी नहीं है. It doesn't happen that way. Now, whether that can be considered as fraud, probably not, because liquidator himself may not be knowing कि ये प्रॉपर्टी उसका है या नहीं. अभी मेरे पास एक ट्रांजेक्शन आया था जहां पे हमने बोला था लिक्विडेटर इज ट्राइंग टू सेल द प्रॉपर्टी ऑफ माय क्लाइंट. because it is in possession of the liquidator. और यहाँ मेरे client को पता भी नहीं है कि उसका property liquidator के possession में. So many times these kind of things happen. Appeal against the contravention from prepaid CIRP into CIRP. An appeal against the order for initiation of the CIRP passed under 4402 may be filed on the grounds of material irregularity or fraud committed in relation to such order. So खाली material irregularity or fraud के count पे ये भी challenge हो सकता है. Next is appeal to Supreme Court. A person aggrieved by the order of the NCLT may file an appeal to the Supreme Court on any question of law arising out of such order under the code within 45 days. NCLT में अपील था 30 days के अंदर plus 15 days extra for sufficient ground. यहाँ पे 45 days plus 15 days है. So Supreme Court में you can file the appeal within period of 45 days from the date of receipt of such order, and the Supreme Court may, if it is satisfied that the person was prevented by sufficient cause from filing an appeal within 45 days, allow the appeal to be filed within a further period of not exceeding 15 days. So the timelines are such that 45 days plus 15 days, that is total 60 days. I hope it's very clear. So these are the stages in CIRP process. We already discussed the stages up to admission stage of the CIRP. Rest is more on the role and duties performed by the CIRP, which can be discussed in a nutshell as given under section 40A of the CIRP regulations, which deals with how the entire process of the CIRP functions. So with this, we finish our session about how the applications are filed, how it is drafted, how it is treated before the Honorable NCLT. Any doubts or query that you have, you can ask.
Thank you so much, sir. Now I open the floor for question answers. Students can unmute themselves and ask the questions if any.
Any queries?
I think so.
Okay.
Thank you so much, sir. I, on behalf of Team Legal express deep sense of gratitude to you for accepting our invitation and for always being there behind us as and when asked. Thank you so much, sir, for spending a splendid evening of your precious time with us today. I also express my deep sense of gratitude to all the participants for evincing interest in today's session. Thank you so much. Tomorrow's session will be at 5 p.m. Please take a note of this. Thank you so much.